Good morning. These are the CEDAW hearings, the Convention on the Elimination of All Forms of Discrimination Against Women, and we're here on Saturday, the 27th of May, 2023 on Gadigal land at the University of New South Wales. And we'd like now to welcome our next witness, who is Gina Masterton from Queensland. Gina, hello. Good to see you.
Good morning.
So we know that you've been admitted as a barrister to Queensland Supreme Court and the Australian High Court, and that was in July 2000. And you're an Indigenous Australian postdoctoral researcher at the Centre for Justice, the School of Justice at QUT, the Queensland University of Technology. You hold a Bachelor of Laws from Queensland University of Technology, a Master of Laws, also from Queensland University of Technology, on the Hague Child Abduction Convention, and you hold a PhD from Griffith University on the Hague Child Abduction Convention. So I would then like to ask, how did you first become involved or aware of difficulties facing women in this area of the Hague Convention?
So I first became involved or even aware of the convention in early 2013 when my own sister was hagged, is like we use that term in this area. And that means that we were living in Los Angeles for several years. I was working there in law firms, and my sister met and married an American citizen and had a child. So when I returned after 13 years to Australia, and she was coming back with me for a holiday with her 2-year-old child, she informed me she'd been in an abusive relationship for about 3 or 4 years. The abuse had been going on that long, but she hadn't, as most abused women do, is not tell very many people about it. So for various reasons. So she wasn't just coming for a holiday, she was coming with me intending to return to Australia, to Brisbane, where we were from. And I had worked in LA for 13 years in law firms, but not in family law, and I'd never even heard of the Hague Child Abduction Convention. So, but I didn't know this was going to open up some sort of issues, international parental issues were going to flow from these actions. So she was only back here for a couple of months, and she was served with an application, a return application that her husband had lodged in Los Angeles through the Central Authority office there, who then contacted the Central Authority office in Brisbane. So that's where it all began in 2013, in about June of that year. So I quickly researched this convention and got up to speed as to what it was all about and why it came to be, how it came to be, and how Australia strictly enforces it against everybody, but even in cases involving domestic violence.
Good, thank you. Well, now, how has Australia's implementation of its obligations pursuant to CEDAW improved, if it has, since we first adopted CEDAW? I think it was actually 1981 that we signed it. And what has improved for women over the last 50 years, and what has become worse?
Well, we actually became a signatory to the Hague Child Abduction Convention in 1986. So that was after we signed the CEDAW. And from the get-go, it has been strictly enforced in all cases. And in saying that can have positive benefits, because the whole intention of this convention is to quickly locate a stolen or abducted child and have them returned to where the courts feel their habitual residence is, so their home. And that is a good underlying reason to have this law. However, ever since the convention came into being, probably at least the last 3 decades, 70 to 75% of cases have involved women fleeing across international borders with their children, fleeing from domestic violence as a last resort. And I think, there's a lot of research around women leaving domestic violence and abusive situations, and it's not something that happens overnight. It's always a last resort. before you throw a few belongings in a bag and take your child and leave your home. And you know, it's always something that has occurred after long-term abuse. So for many years, at least the last 25 years to 30 years, the rate of women fleeing with children has been around the 70% mark. So even though this has been known and acknowledged by even the Hague itself, when they had a meeting in 2017 and acknowledged that this was the case and had been the case for a long time, nothing got changed as far as the amending the convention at that time, and nothing has really changed much here either, or in any other country that signed the Hague Convention. So I would say nothing has changed, except for maybe this year when the Attorney General amended our regulations to allow judges to consider domestic violence evidence, whereas before they didn't. They always had that option, but it wasn't it wasn't something that had been added to our regulations. So now it's officially in there. They're allowed to look at domestic violence. It's not something that they have to look at. The verbiage they use to amend our regulations doesn't really force judges to look at domestic violence. So nothing's really changed as far as the practice in courts. The Labor government has offered up $18 million in the budget to help fund women who face HAGUE applications to somehow, I don't know how that's going to work, what the setup's going to be, but that is to go towards legal costs for mothers, which they never had before. So that's a good thing. I always take these positive changes because it's better than nothing. A big issue with these cases was that when abusive men lodged return applications, already here, they had the full force of our federal government behind them. So very good trained solicitors who work for Central Authority, very good barristers who they retain, and they have like a 95% success rate of returning children, maybe even higher. So mothers didn't have access to any funding from the government through legal aid or anywhere else to fight these applications. But with this money coming now, that may change. We'll have to see, and how long that will take to filter down, I don't know, because these cases are happening every week in the family courts around this country. So 2 positive changes have occurred this year. It's not enough, but I'm taking it. I'm grateful for small mercies. So to answer the question, not enough's been done.
Thanks. I should clarify too, of course, Australia did sign CEDAW in 1980, and as you said, the Hague Convention in 86, and we ratified CEDAW in 1983. I said about signing 81. I was thinking about another jurisdiction, so I just need to clarify that. But over to you then, Kerry. Yeah,
okay, how has Australia's implementation of its obligations pursuant to CEDAW improved since its last report back to CEDAW in 2018? And what has improved for women over the past 5 years? I think you've actually touched a little bit of that, but you've clearly shown there's a lot more to go. Is there anything that's deteriorated or become worse?
Well, domestic violence, as we all know, is just still it's at epidemic level here in this country, domestically, and I still don't think enough's been done by our government to educate around that, to prevent it, and then to also support women once they do leave. I mean, it's still extremely difficult, despite all the great work that charities do here and other organisations, to even get a place to stay when you have to leave because you just cannot stay one more night. I mean, a lot of women leave without money, without a credit card, without any planning. They just have to leave and take their child with them. So I mean, there's still not enough of the basic things: somewhere to stay, something to eat, someone to talk to once you get there. I mean, we need a lot more shelters in this country, especially in the rural areas where women really have even fewer opportunities to find a safe location. And if you're in a rural area, a remote area, then everyone knows you and everyone's, it's an even worse situation. So we need more practical and emergency type support. Like I said, like somewhere to go, somewhere to stay that's safe, somewhere where you can get a meal, where you can stay for a couple of weeks to get back up on your feet, to be able to talk to Centrelink or other services. For women who really do have to leave to save their lives, there's not enough of the emergency support on the ground right now, in any state.
Thank you. So just moving to question 9, what needs to change now, and how can these changes be best achieved?
So thank you for the question. So the regulations have to be further amended. I mean, I am still working with other women here in Australia and in the UK to force governments to amend the Hague laws. I mean, once you adopt it, that's fine, but you can mold it to fit your culture. I mean, other countries do it. They don't adopt it verbatim. They have it so that it fits their culture, so the people can live with it. So our Hague regulations have to be further adopted to better protect abused women fleeing domestic violence, or women coming to these cases with evidence of domestic violence and abuse, so that if it involves any kind of evidence where women can show this is why I've left, and it's I have orders, I have paperwork, I have documentation from the courts, from the police, from my doctors, especially in those cases where they can support the allegations, there should be no order made to return a child to that situation, because if the order is made to return the child, the mother will go. A lot of these mothers get further abused, harassed. Some get murdered when they return with their child. There's no statistics kept on this, but it is widely known within the Hague Convention community of both here in the UK that a lot of mothers die at the hands of these abusive men. So we need some much better amendments around our laws, and if it involves a First Nations child, then something has to be put into our Hague regulations that says no First Nations child is ever being removed from Australia, because that's happened in a few cases, and one just recently, so just before Christmas, and it's like stolen generation all over again. So when it comes to a First Nations child, that should be absolutely taken off the table, that child will be taken away from this country. And they're just a few things that I'm putting out there that are the most important ones.
Yeah. Well, question 10, Helen, I think you were going to.
Yep. So the next question is about the recommendations that you would like to the CEDAW Committee to make in this framework, and could I leave? Give you an open question on that. But one question that I think would be really useful to address is what would be the mechanisms or measures that we could take to ensure that no First Nation children should ever be removed from Australia where there is a conflict with Hague? Because I just remember in the most recent case that you're talking about, a couple of academic suggested that it was a very mistaken approach. I think it was said that it was against the UN Declaration on the Rights of Indigenous Persons, and that Australia had ratified that. And I said, well, it's a declaration. How could they have ratified it? But and so there was this sort of misunderstanding, I think, of what would be needed in order to make that binding on Australia. And then the more general question of what are the recommendations that you would make.
Yeah, so your recommendation, no First Nations children should ever be removed from Australia to another country. How could we make sure that happened under the Hague Convention? How would the Hague Convention have to be amended, and would it have to be an actual amendment to the Hague Convention, or do you believe, with your legal knowledge, and you're the one that's done the PhD in this area, which we thank you for very much, but how could we do that here in Australia?
Thank you all for that question, and it's a very simple fix. The Hague regulations we have in our Family Law Act have to be overhauled, and should be a round table where people are invited, myself included. I'm put my hand up for that, and other people who are interested in having the Hague regulations amended, other lawyers, other academics, some Hague mothers, as there was a recent round table that was held by the Family Law Council that I was fortunate enough to present to. The regulations are not that long, they're not that complex. We've actually adopted the Hague Convention and thrown it into our Family Law Act pretty much verbatim, and that's what we did, and that's what we've been going by. Family law judges here have chosen for the most part to not change the law through precedent, which is how laws do get changed, rather than having legislative amendment. I truly believe these laws are not going to change through judicial precedent, so it has to be through legislative amendment, and it has to be in a situation where a lot of people are involved, such as myself and other people who are passionate about this. But it has to be an amendment in the Hague Regulations saying First Nations children, Australia's First Nations children, are simply not going to be returned under a Hague application, and because they would miss out on growing up with their culture and with community and with tradition. And for all those reasons, and because of Australia's history with doing that with Indigenous children, we simply cannot allow that to happen again under any law. So this would just be, an instance of us putting that in there, because once these children are returned to other countries, there's no way they can catch up on everything that they learn growing up here and with their culture. So you have people growing up in other countries who are going to be displaced. They're going to feel that they've lost something they can't get back. So it's a matter of amending the regulations to say that.
Can I make a comment here? I don't know if you can transfer one decision of the High Court to another area, but wasn't there a decision by the High Court that people of Aboriginal descent cannot be deported to another country? It was in the case of them wanting to deport them because there were people of not good character, according to Dutton, but the High Court held that could not happen. Now, if that principle occurs in that concept or in that area, could not that apply across into the Hague Convention or the Family Law Court as well? I mean, you've got the legal background for this.
I'm not sure. Do we know where? I know that issue is before the courts, because you're absolutely right. It was a case where there was a contention that the Indigenous Australian man had citizenship from another country, and therefore he should be robbed.
There were two of them.
Yes, they could be robbed of their citizenship, their statehood. They could be made stateless, and then of course the other country is saying, well, they don't have citizenship of our country. So I don't know that it's that the High Court has decided on that.
There has been a High Court decision.
They have they?
There have been High Court decisions saying that a person of Indigenous origin the government has no right to
render them stateless,
or even to remove them to another country for which they have a dual.
So that was a criminal case. Yeah. And I don't know that the citation of that, but it was a criminal case, and it did involve a quite imaginative defence for a man who had an Australian Indigenous heritage and also New Zealand heritage, and he was to be deported back to New Zealand. This was a couple of years, well, not that long ago, probably only months ago. And his lawyers argued that to deport him from here would deprive him of his Indigenous culture. So that was the first time that argument had been raised from that I know of in a criminal case, and that argument was made, and I think the court did uphold that argument, and I don't think he was deported. But to drag that across to family law cases, it's really just throwing the dice, because it's not in the same. It's a criminal case, not a family law case, and also judges have a habit of not recognising precedent from other areas of law, That's why I'm saying if it was amended, if that amendment was put into our Hague regulations, the judges couldn't ignore it and go, well, I've got discretion to make this decision or send this child back or not send this child back. They would have to go by what the actual legislation says, and that is the best way to keep Indigenous kids in Australia, even if it's in legislation.
I think it's a very different issue as well, because both of them were born outside of Australia, and so there was the idea, Dutton's idea, or Dutton and his ilk's idea, was that they were aliens and could be deported, but they were of First Nations descent, and they did, in their case, much to the anger of Dutton, and which we all delighted.
Refused to release them anyway, or one of them, even after having.
So it's sort of, there was a case about whether they were aliens for the purposes of deportation. So I think it's a bit remote from the case.
Could I just actually say, what about we have signed up to the convention, the Genocide Convention, and in the Bringing Them Home report that was done by the Australian Human Rights Commission, it was considered that removal of children from their parents, their home, was genocide. So it may be that that could have been used by in a decision. It could have been used as an argument in the Hague Convention issue. But of course, yours is the more straightforward and simpler approach, which is to say that the regulations should be changed. But I did, before handing over to Mary, because we should allow time for her too, and I see we've got our next witness coming, but you've done this PhD. Have you actually been consulted by the Attorney General of Australia that is conducting this inquiry into the Hague Convention? Because if not, then in my opinion, he's overlooking the Australian expert in this area, and it must be brought to his attention that he should be consulting with you. So have you been contacted or consulted with?
Well, the Law Council roundtable that I was involved with a couple of months ago did include the Attorney General's office and included central authority representatives. There were other feminist lawyers there who are from the Philia organisation in the UK who we're all kind of working with we're simultaneously working to see if we can get it changed there as well as get it changed in our own countries. So there were a few different people there, but Attorney General's office were there, and they did hear me say the same things, and they did hear me say the simple, easy, cheap way to fix these issues is basically to amend our Hague regulations and our Family Law Act. And the Attorney General's done it just recently like that. He's gone, well, I'm going to just, put this amendment in here and, and then immediately it's effective. And the amendment was, I'm allowing judges to now look at domestic violence evidence if it's offered. He should have said they must be looking at, they must, but he didn't use that language. So kind of, it's a bit of a soft punch. So, but yeah, they were involved, and the Deputy Chief Justice of the Family Court was there, and he had, I've been told, read my PhD, not word for word, but he had a good look at it, and that's why I was invited to come and present. So there are some people in the Family Court, Attorney General's office, seriously wanting to do something around this, and I think now is the time. The best thing to do, the easiest thing to do, the cheapest thing to do is just amend these regulations to better protect abuse.
Fair enough.
It's a good, simple, straightforward, powerful solution. Very good.
And Mary, did you have any issues?
I just would have liked to have known a little bit more about your story and the impact that it had, and on your sister as well, and the child in the end of that.
Yes, thank you. Just quickly, because I know you're moving on, but my nephew's 12 now, so he was 2 at the time, and like I said, I had to learn about this very quickly because it all happened very quickly, and that is the thing with this. It's a 6-week turnaround, and it even says that with the Hague explanatory report that came with the convention, which says, explains a bit about it. And it said, we've got to turn these cases around quickly so kids don't get settled in the new place where the mother's taken them, when they just get sent back. And really this law came about because in the 70s, a lot of fathers were taking children, mostly from Europe, to countries where mothers couldn't get them back easily. So they were abducting their children to Middle Eastern countries, and it was, impossible to get these children back. So the Hague did a good thing. They came up with this convention. They said, let's get the kid back quick, back to the mother. And then that's not to cut the father off, but you need to then go through, the domestic family law process in the child's country and work out parental rights there. So I call it a good law gone bad because it was drafted for good reasons, but then when used against mothers fleeing, extreme domestic violence with their children, it has whole different consequences and impacts. So my sister ended up having to go back to LA for 3 months, mediate with her child's father, and he eventually, because it's all about power in these situations, not really about I want the child, he had met someone else and was involved with that person then, so he allowed my sister to bring my nephew back, and he's remained here, growing up here. And his father actually did move here not long after and remarried, and he has a relationship with his father, which is, this is the fairy tale ending to one of these situations, and it's a very rare ending because most cases do not end this way. So he's maintained, my nephew's maintained, being able to grow up with his culture and in his community and knowing his grandparents and other family, whereas if he'd grown up in LA, he wouldn't have had that. So he's managed to maintain that. It's not always a great situation when these things happen, but you do have to think about the best interests of the child, and that is not the standard by which these cases are decided. That's another thing that needs to be put into our regulations. That needs to be made the standard and a test. So all in all, the adults have to stand back and go, what's the best thing for this child? But my nephew did end up growing up here. He lives with me to this day, as my sister does, and he sees his father pretty regularly.
Oh, thank you so much. And just, we are ending, but I wanted to refer you to this recommendation you've made too. An applicant father with a history of abuse or violence or protection orders against him should not be permitted to enter Australia. If he is to be a witness, he should have to appear for any court hearing via online access from his own country, so the abused woman is not in fear for her safety or her children's safety. That's an excellent recommendation. Do you want to just speak to it for a couple of minutes, Gina?
I will speak to that very quickly, and that has happened a lot. I interviewed 10 women for my PhD, and half of them said that was the situation with them, that they had these orders, and one jurisdiction had said, this guy's a bad man, this guy's a dangerous man, and yet Australia had let him in. So to be, goodness knows what his, plans were. But not only did they let him in, but our government fully supported them with, like I said, the best solicitors at the Central Authority who slam dunk these cases because, there's a formula and they know the formula and they have a very high success rate. The best family law barristers. So they let him in. He's not a good person. He's probably a dangerous person. But then he has the full force of our legal professionals behind him here, and he ends up, while he's here, continuing to further abuse, harass, intimidate, threaten the mother of the child, taunt her. I've got lawyers that I don't have to pay for, and you're having to have your parents mortgage your home, or your parents use all their superannuation to pay for a lawyer, and you're going to lose anyway. So this is all the stuff I heard when I interviewed women. Woman with the Indigenous mother just before Christmas, who I'm very close with, and her little girl who's 2, she had the same thing from a European country. She had, and from here, she had evidence and she had orders and protection orders here. And yet they allowed him to come in here, and the same thing happened. So not only did they ignore these orders, but they went straight to work to persecute this mother, prosecute her. And another thing is they've criminalized this now. So the Hague Convention is an administrative process, but now Australia and other countries have as well made it a criminal act if a mother brings a child over an international border to our country, and you can go to jail now here for that as well. So not only are they letting these bad men in and then fully supporting them with our legal system, giving them back the child, but the mother may go to jail too. So I mean, it's a pretty awful situation for a woman. All she wanted to do was get away from being beaten and threatened and harmed, and having a child see that. I mean, what a price to pay for your life.
And for representing your child's interests.
Yes.
Yeah.
Being a mother, you know.
That's right. Oh, thank you so much, Gina. Now, has your PhD been published? I mean, by a commercial publisher? I think it'd be very important to pursue that possibility. No, absolutely seriously, because it's a really important issue, and I'd be happy to be in touch with you about potential publishers and so on.
Thank you so much. Well, you know where to find me.
Yes. Thank you, Dr. Gina Masterton. Thank you.
Good afternoon.
Thank you.
And we'd like